Go one more week.
Counsel, have any objection to
that? No, Your Honor. Don't have an objection to that.
Okay. All right. Well, if you did, then...
All right, court watchers, listen up. This is the probable cause conference, the legal pregame. It's where the prosecution drops just enough to keep the case alive. Think of it like this. Is there smoke? If yes, then was there fire? Begin bon school.
Let me know. All right. Preliminary examination in person, April 1st, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case, People versus Zachary Broder.
There's appearing on behalf of people, Your Honor.
Good afternoon, Your Honor. With us on behalf of Zachary Broder, who's joining us by Zoom.
All right.
I think he's there.
Yes, he's there, and I just need somebody to unmute. If he could state his name, please.
Zach Broder.
Thank you.
Your Honor, the court had been in receipt a few weeks, approximately a month ago, or just slightly less than that, of a report from the Center for Forensic Psychiatry finding the defendant incompetent and not restorable.
Correct.
Just as a bit of a backstory, just so I can make an appropriate record, the facts of this case involved an accident where the defendant was traveling at a high rate of speed, car crashed, and the front passenger in that vehicle died. The defendant also suffered a number of brain injuries in that accident, and as a result, led to the report which the court is in receipt of. Because of the fact that the defendant, the reason for his lack of, or his incompetency is a brain injury, there's no reason to believe from the Center for Forensic Psychiatry standpoint, or in my review of both that report and the relevant case law, that I have any reasonable expectation that a petition would do any good as far as this case in the future. If there's any reason to believe that even over a long period of time, there could be some competency restored, that may be a route that we would go. That is not the case here, nor do I have any reason to believe that the defendant not being under mental health.
Archer, whoa, major legal moment here. The state is moving to dismiss the entire case. Not because he's innocent, but because he's been declared incompetent and not restorable. That means due to a brain injury, he's not mentally fit to understand the process now or ever. And in the justice system, competency is non-negotiable. But
is creating any danger for himself or others. So for those reasons, at this time, the people would be moving to dismiss this case without prejudice, and I'll have a knowledge process filed with the court.
Is there any objection to any of that?
There's not, Your Honor. That's all fair what Mr. Childers represents.
The case is dismissed then.
Thank you.
Thank you, Mr. Broder. Good luck to you, sir.
All right. Thank you.
Say thank you.
Thank you.
Court does call the case, People versus John Cahill.
Your Honor, Joe Simon on behalf of Mr. Cahill, who should be present on the Zoom. And Chuck, unmute his device and let him state his name, please.
Wait, we're not on.
There. How's that? Terrific. State your name, John.
My name is John Cahill.
All right, thank you.
And we have such day for a probable cause conference. At this time, the people have extended an offer to the defendant to plead to the currently charged count 2 in exchange for.
So the charges are dropped for now. It's dismissed without prejudice, which means the state could technically bring the charges back if something changes. But with the medical outlook as it is, this case might be closed for good. Let me know in the comments. Do you agree with the dismissal?
Dismissal of count 1. I understand that he's going to accept that offer and proceed with the plea today.
Is that a correct statement?
It is, Your Honor. Mr. Cahill and I, as you can tell, I can't really meet him in my office, but we did review together the advice of rights form, and he permitted us to sign it on his behalf, and he's ready to enter his plea.
All right. Does he have the physical ability to raise his right hand?
I don't know the answer to that question.
All right. All right, Mr. Cahill,
Yes, Your Honor.
All right. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. Can you state your name again for the record, please, sir?
John Cahill.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating with a high BAC. Is that your understanding?
Yes, Your Honor.
All right. That's a misdemeanor, punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. Do you understand all of that, sir?
Yes, Your Honor.
All right. And understanding all of that, do you still wish?
Now we're stepping into the world of plea deals, quick, efficient, and often controversial. Cahill is about to plead guilty to operating with a high BAC. That's blood alcohol content. And trust me, the number the court's about to reveal is staggering. Penny.
Plead guilty.
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You went through an advice of rights form and gave Mr. Simon permission to sign your name to that. Is that correct?
Yes, Your Honor.
All right. Did you have any questions regarding any of those rights?
No, Your Honor, I do not.
All right. And in paragraph 5, those explain your trial rights. You understand that you're waiving those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
All right. Are you on probation or parole, sir?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
October 4th, 2023, at East Michigan Avenue near Moon Road in Pittsfield Township, were you operating a motor vehicle?
Yes, Your Honor.
All right. Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
All right. Do you recall what you had and how much?
A couple cocktails, Your Honor.
Were you stopped by the police or was there an accident?
There was an accident, Your Honor.
Okay. And at the accident, did the police arrive?
Yes, Your Honor.
All right. And were you taken to the hospital, sir?
Yes, Your Honor.
All right. And did you have your blood drawn?
I believe so, Your Honor.
All right.
Yeah, the people would allege a 0.175 blood alcohol content. I don't think that's in dispute.
It's not. We stipulate to that.
All right. Do you have any reason to dispute the blood test results in this case, sir?
No, Your Honor.
All right, very good. Based upon that, counsel, has the court complied with the court rule and would it be proper to accept this defendant?
People are satisfied.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at court.
It's your matter, yes.
Pardon?
It's your matter, yes.
Yeah. So a pre-sentence investigation in order is ordered at 14A1 probation. Sentencing will be April 9th, 2025, 9 a.m. That's
Judge. To plead guilty. Yes or no? Defendant. Yes, Your Honor. Judge. And to that charge, how do you plead? Defendant. Guilty, Your Honor. Judge. You understand that by pleading guilty, you won't have a trial of any kind? Defendant. Yes, Your Honor. Judge. You went through the advice of rights form and gave Mr. Simon
for me.
Thank you, Your Honor.
Your Honor, and thank you. Is there a way, would the court permit if I can work it out with your probation department, if he could report by video? If I could.
Yes, I'm not gonna have a problem with that. I thought maybe, but we don't have them up today, that we might have been able to put him into a breakout room right now, but yeah, if they, that's fine with the court.
Thank you.
Whatever way is satisfactory with Ms. Valera. All right, bond will continue.
Thank you.
All righty. Thank you, Mr. Cahill.
Your Honor,
Thank you.
Yes.
while I admit to aspiratation and control, the staple in question resides in the court's file right now.
Oh, it does?
There's no permanent intention of deprive permanent.
So the staple is back to its rightful home. Good.
Next case on the docket.
Those case, People versus Zachary Bruder.
Andrew Childers appearing on behalf of people, Your Honor.
Good afternoon, Your Honor. Uwe Dawes on behalf of Zachary Boda, who's joining us by Zoom.
All right.
I think he's there.
Yes, he's there, and I just need somebody to unmute. If he could state his name, please.
Zach Burr.
Thank you.
Your Honor, the court had been in receipt a few weeks, approximately a month ago, or just slightly less than that, of a report from the Center for Forensic Psychiatry finding the defendant incompetent and not restorable.
Correct.
Just as a bit of a backstory, just so I can make an appropriate record, the facts of this case involved an accident where the defendant was traveling at a high rate of speed, car crashed, and the front passenger in that vehicle died. The defendant also suffered a number of brain injuries in that accident, and as a result, led to the report which the court is in receipt of. Because of the fact that the defendant, the reason for his lack of, or his incompetency is a brain injury, there's no reason to believe from the Center for Forensic Psychiatry standpoint, or in my review of both that report and the relevant case law, that I have any reasonable expectation a petition would do any good as far as this case in the future. If there's any reason to believe that even over a long period of time, there could be some competency restored, that may be a route that we would go. That is not the case here, nor do I have any reason to believe that the defendant not being under a mental health petition is creating any danger for himself or others. So for those reasons, at this time, the people would be moving to dismiss this case without prejudice, and I'll have a nollie cross filed with the court.
Is there any objection to any of that?
There's not, Your Honor. That's all fair what Mr. Childers represents.
The case is dismissed then.
Thank you.